my husband and I were not the legal parents of my daughter when she was born in 2017. And I was 100% the biological donor of the egg, and my husband was 100% the donor of the sperm. It was 100% genetically our child, but we were not on the birth certificate. Is not only did we wait 9 months for her to be born, but after she was born, we then had to file a petition in court, wait another 9 months to get through the court system, and finally be declared her parents through a post-birth judgment of parentage.
Hello, everyone. I am very excited to bring Jennifer here, who is a New York attorney on our directory, but she went through a surrogacy journey herself. So she's here today to talk about her own surrogacy journey, as well as tell us about the new law in New York that allows for surrogacy. So take it away.
Well, thank you so much for having me. I'm really happy to be here, and I'm really excited that this new law has come out in New York, and it grants so many more options to folks that are in New York. Just to backtrack a little, I did go through my own surrogacy journey back in 2017, and my wonderful daughter was born at that time. I've been an attorney for close to 20 years, but I've been doing lots of other things, and it was only through my own experiences that I really fell in love with this area and fell in love with the people that need the legal representation to go through this. And family formation is such an important part of my life. And I want it to be an important part of my, not only my personal life, but my professional life as well. So back in 2017, my husband and I were trying, or backtrack even further to 2015, just after we got married, we were trying to have children. And unexpectedly, we had fertility problems. And I had never even considered or really paid any attention to the idea of gestational surrogacy before. But, with all of the problems that I was having, I basically had an uncooperative uterus. So while I could get pregnant, and I did a few times, I would lose the baby each time because the implantation just wasn't happening and I wasn't able to carry it to term. And that was really heartbreaking. And so I know a lot of people have gone through that sort of situation. My sister, as it turns out, is a wonderful person. And I always knew that, but not quite how wonderful she was. And she was a labor and delivery nurse. So she was around babies and these sorts of situations all the time. And at some point, when she saw me going through this, she approached me and said, if you need someone to carry a baby for you, I'd do it. And you can imagine that I was pretty surprised, thankful, but surprised. And I was like, I never really fully considered that, but let's see. And after talking to the doctors, it turned out that that was the avenue that we needed to take. And so I was really, really lucky. And I know most people are not that lucky that they have someone like that. But I had my sister and she was willing to carry our baby. And so we went through the whole process. She was unpaid because at that time, I don't know if she would have even taken payment, but it wasn't an option for us because at that time, paid gestational surrogacy. And by the way, gestational surrogacy is where the person who's the surrogate is just carrying the baby and doesn't use her own egg. So it was actually my egg, my husband's sperm, and my sister was the oven, so to speak. And it was illegal to do paid surrogacy at that time. So this was unpaid surrogacy. So fast forward 9 months and the whole process later, and then we had our beautiful baby girl, Eliza, who is now 3 years old.
I love that. That is so magical. I mean, I've talked to a lot of attorneys in the surrogacy, arena now, and I'm just like, wow, it takes a very special person to be a surrogate. Like, I went through it myself for my own children, pregnancy, and yeah, you can't pay me to do it for someone else. So it's amazing and so incredible. So I know, because I know you, that you were in various types of law before you got into doing family formation. So, and that your experience with surrogacy led you to saying that you want to help other people.
Yeah, absolutely.
Of law.
Yeah, I was doing child welfare law when I first started out of law school back in 2002. And I did that for 9 years. I was prosecuting child abuse and child neglect cases here in New York, in the Bronx and in Manhattan. And that was really rewarding. Um, from there, I sort of went down to Washington, D.C., and I continued that kind of work as an assistant attorney general. And then I came back to New York. I really missed New York. And so I came back to New York and I found a job doing something completely different. And I became a trial attorney for an insurance company. And I was presenting cases to juries. And that was an exciting area, but it wasn't an area that was a passion of mine. I did it. I was good at it. I liked it, for what it was. But it was really through that time period that I was finding myself in my fertility challenges. And after going through that myself, I said, you know what, I need more out of life. And I want my professional focus to align with my personal feelings. And there's so many people out there in various different communities and in various different stages of their own family formation. And I wanted to be an attorney that would help people do that. So it's not just because this is an exciting new time in New York because we have this new law, because I really have that personal connection to it. And so it's really, this is where I'm at and this is my passion and I want to help as many people as possible.
I love it. Yeah, I think that once you've been through it yourself, you have such a different appreciation for it. I mean, we went through fertility to have our children, and connecting with other people who've been through that process, it's just, it was life-changing, to be a part of a community that understood, how hard it was, and, a lot of needles and, and all of that, but just to, it's, I think you bring a different perspective to the table than
Yeah.
other people because you've been through it. And this type of law is so emotional. People are coming to you very broken a lot of the time. And, to be able to say, I actually really understand, it's, you need to be able to bring that compassion and empathy to what you're doing. And so it's amazing that you transitioned to doing this type of law. Okay. We've got a new law now in New York. So as you had said,
We do.
unpaid surrogacy was illegal. You literally
Paid
couldn't do it.
surrogacy was illegal.
Which
You
is
could only
crazy.
do unpaid.
Right. Which is crazy.
Yeah.
Is crazy. So now, as of February 2020, we have 2021. I'm like, what? I don't know what year it is anymore. We have a new law. So talk to us about that.
Sure. So as of February 15th, 2021, we have a new law that came into effect. It was voted on back in April of 2020 during COVID, and it passed and it came into effect just about 3 weeks ago now. And that allows for paid gestational surrogacy in New York, which is amazing because not everyone is going to have a sister, a family friend, a coworker that can act as their surrogate in New York. And now we have folks that can be surrogates and can give to others in their community, to their friends, to people that they don't know, and be those surrogates for folks in New York. It's a really great law. It opens up a lot of different opportunities, especially for New Yorkers. And I say that because there are eligibility requirements, and some of those eligibility requirements include residency requirements. So this is not for international folks that are looking for going through a surrogacy journey. This is really focused on New Yorkers. And that law may be amended at some point to include some other folks, but right now it's really focused on New Yorkers. So this is for folks that are surrogates in New York. There is a requirement that the intended parents and that the surrogate be US citizens. The surrogate must be 21, the intended parents at least 18. And when I say 21, I mean at least 21. Not just 21-year-olds. The surrogate can't use her own egg. So this must be an egg that's either a donated egg, a donated egg that's part of an embryo that's being donated, or the intended parent's own egg. So that's a very strict requirement. This is not for surrogacy that we call traditional surrogacy, which is where the surrogate uses her own egg. This is gestational surrogacy only, where another egg is used. And that information is going to be very clearly laid out in what we have called a surrogacy agreement. And the source of the egg, the source of the sperm, all of that is going to be in the agreement. And that's something that's very important. This law is gender and marriage neutral, which is really great. And it's not the same in every state. This is really a groundbreaking law that we have here. It doesn't matter if you are an individual woman wanting to have a child. It doesn't matter if you're an individual man wanting to have a child. If you're same sex, if you're married, if you're unmarried, you all can be part of this and all be intended parents. The requirement is that there be a New York surrogate within New York, at least one of the parents being a New York resident, and that residency has to be for at least 6 months, if not longer. So that's why I say that it's really for New Yorkers focused, and this may change in the future with further amendments where folks outside of New York can take advantage of this, but right now the focus is really on New Yorkers. Like I said, you can be married or unmarried if you're an intended parent, and if your marital status should change, that's something to be aware of, because if you enter into a surrogacy agreement and you divorce at some point or separate at some point during the pregnancy, your obligations are still going to remain. So it's really, you have to be very careful with doing this, that you know that you're going to be obligated to this child. And that's a really great thing, actually, that you're going to be obligated to this child throughout, from the time that you sign that agreement all the way forward.
Right. Right. And I know that we talked before about the importance of the surrogate having their own attorney, as well as the intended parents to have their own attorney as well. Just to make sure that everybody knows what's going on, and there could be conflicting interests potentially in that regard. So talk about that.
That's been a best practice that's been followed in a lot of different states. ASRM, which is one of the premier bodies that deals with this, it's the organization that a lot of the doctors go by, a lot of the attorneys go by, because there is no actual regulatory agency for the country on this. But oops, sorry, I think I went mute. ASRM guidelines have been followed here in the codification of this law, and has gone even further in creating a surrogate's bill of rights. Now, we're the only state in the country that has what's called a surrogate's bill of rights. And one of those rights, there are 6 rights that are granted there. One of those rights is that the surrogate has a right to her own independent legal counsel. And that is independent from the intended parent or parents. I should say that if the surrogate has a spouse, that spouse is also represented by that counsel. And that spouse is also a party to the agreement and a party to the arrangement, and is involved in this, unless she has been separated for a significant period of time. So they're going to be involved in that. With that surrogate's bill of rights, there are other things that come along with this, and that's very unique to New York. And it really makes sure that the surrogate is protected. When the drafters were drafting this and the lawmakers were passing this, they wanted to really make sure that surrogates here in New York were well protected. And in that surrogate's bill of rights, I said there are 6 things that are granted to them. And one is the independent counsel. The second thing is that they can terminate the pregnancy. They can terminate the agreement anytime before the pregnancy happens. And both parties, both sides of the agreement have that, the intended parents and the surrogate. But the surrogate has that specific right, which is important, because if she has cold feet, she doesn't have to go through with it. The surrogate is also allowed to have counseling, and that's mental health, behavioral counseling, for up to 12 months after the end of the pregnancy. So that is very unique in New York. That is paid for by the intended parent. So this is not an area that is going to be inexpensive, but it's very protectionist of the surrogate. And that's to make sure that she can deal with any postpartum depression, anything that may come out of this, because she is taking a lot of risks. The surrogate's bill of rights also says that the surrogate is to have health insurance coverage, comprehensive medical coverage, and that goes for the entire pregnancy, and that goes for up to 12 months, or the full 12 months after the end of the pregnancy. Again, that's paid for by the intended parents. So it's important to have that insurance in place. They are also entitled to life insurance with a policy of up to $750,000. And that life insurance policy goes again for 12 months after the end of the pregnancy. And that again is paid for by the intended parent. And so that's something that needs to be secured as well. And lastly, but not to be minimized at all, in the surrogacy bill of rights, or the surrogate's bill of rights, the surrogate is the one that is entitled to make all of the health and welfare decisions regarding herself and her pregnancy, because they really consider this to be her pregnancy. The child that will be born, or the children that will be born, will be the children of the intended parents. And everyone understands that from the beginning, and I'll get into that in a little while. But the pregnancy is owned really by the surrogate. So the surrogate has the right to decide how many embryos are going to be transferred to her. She has the right to make her decisions regarding who her medical doctors are going to be, or if she's going to change that doctor. She has the right to make the decision, and this is a big one, about termination, whether it's selective termination or selective reduction, or it's actual termination. And those are things that, because it's her rights, here in New York, it's very important, and I think it's important in any surrogacy agreement, that the intended parents and the surrogate are on the same page and talk about these important topics right from the beginning. Nobody likes to talk about what happens if, but that is exactly what needs to be done here. And it's codified in the law. It is required that everyone talk about these things, because it's so important to know that it's the surrogate that's going to make those decisions. And so everyone needs to be on the same page when you do all of this. Mm-hmm.
Yeah. So with that, and you mentioned that to me before, and I was, hence why I wasn't as shocked this time when you said that, but I was shocked the first time. Is there a way with this termination? I'm assuming you can't contract anything beforehand of like, I will not terminate this pregnancy without the consent of the intended parents. Like, I'm assuming you can't do anything like that.
Well, you can and you can't. So
Okay.
there is going to be, and there must be, a written surrogacy agreement, and that is drafted usually by the attorney who is representing the intended parent or parents, and it is reviewed and negotiated by that attorney and the attorney representing the surrogate. Now, going through the matching process, which happens very early on, before the medical clearances, before the psychological clearances, which are other requirements that this surrogate needs to meet. She needs to pass those clearances before she can even really get engaged in this process. At the very beginning, they're going to be addressing those things. So we're going to make sure from the very start that the parents and that the surrogate are on the same page, and that the surrogate is giving her informed consent about the processes that are going on here. So it's very out in the open. When it comes time for the legal portion of this, which is the drafting of the agreement, I say yes and no, those things can be in the agreement, because what will be in the agreement is everyone's intention. So it's going to be phrased somewhat along the lines of, the surrogate intends to reduce if X, Y, and Z without expressly guaranteeing it. So the intentions are going to be clearly in the agreement itself. And so everyone's going to know what the intentions are. However, there's no specific performance allowed in New York in these surrogacies. So if a surrogate intends but did not guarantee, which is how it will be, if she intends to reduce for a certain reason but does not reduce, or reduces for a different reason that was not, specifically discussed, or should have been discussed, but not specifically stated beforehand as her intention, you can't make her keep the baby. You can't make her reduce if she doesn't want to. It's going to be her decision, which is why it's so important that, especially in New York, especially with this law, that everyone's on the same page. And I think that we're going to get to that point, because there are so many steps that you take before you get to that point. So most likely, people are not going to be having problems at that stage, but you can't guarantee it. And so no, you can't say 100% what's going to happen. You have to put some trust and some faith that it's been vetted and discussed, and that people are going to follow what they say they're going to do. And you can't force a baby back in. You can't force someone to do something with their pregnancy that they don't want to do. And that's really
it's crazy though, because like, as someone who carried a pregnancy, like, yeah, I mean, I get like it's your body, and I totally believe that no one should ever tell a person what to do with their body. I mean, hello, legislatures. But at the same time, it's like, but that's not your baby or babies.
right.
So that's so hard.
Yeah, and that's why it's so important to have the psychological piece, the evaluation in the very beginning. That's why it's so important that everyone is discussing this as openly as possible, and everyone really takes the time in the front end to make sure that we're talking about these things and we're getting on the same page. You want to make sure that you're matched with the right person, because there are other people out there that have the same feelings as you. There's surrogates that have the same inclinations as the intended parent, and it's important that you match the right people. And if it's not a right match from the beginning, if you have any qualms about that, you need to speak up and not get engaged in this kind of a surrogacy, and look for another surrogate or look for another set of intended parents if you are the surrogate, because it's really important that you're on the same page. Now, that said, if someone was to, say, terminate when they didn't state previously if they intended to, the intended parents or the aggrieved party has all rights available to them at law and equity, which means that they could bring some sort of a challenge in court, perhaps under a violation of a contract. It's really unclear if they're going to get anywhere with that.
Right.
But
And you can, I mean, well, you can't get
speak-
that baby back, so it's not like, right.
Exactly.
So there's still some, I mean, as with any new law, there's still some things to be worked out, to be still
Yeah.
to be seen.
Yes.
So we touched upon a little bit this before. So let's say we have a cis hetero couple that are intended parents. So we could have an egg and sperm from that couple, create the embryos. But what if we have a third party,
Mhm.
sperm, egg, embryo? What is different then about that contract? Because now it's not, you know, the parents' biology.
Well, one of the great things about the CPSA is that the law specifically provides for that. And it creates a way for a donor to really be seen as a donor. So if you have a situation like that, whether it's an embryo donor or one of the gametes is being donated, either the egg or the sperm, if it's a known donor, you really want to make sure that you have a donor agreement. And that donor agreement will be your record that you will reference in your surrogacy agreement and later in your parentage petition, showing that there was really donative intent. So this law really comes back to the intent of the parties or the participants. And one of the participants in this whole scenario is one of those donors. And if that donor shows right from the beginning through some sort of a record, and with a known donor, that would be an agreement, that they intended only to be a donor, then that should show that they're a donor right through to the end, and they should not be having any parental rights. And so that's going to protect all parties. If it's an unknown donor and it's truly an anonymous, let's say it's a sperm bank or an egg bank or an embryo bank, with those, what we would use is the record of the donation. They're showing that the person donated to this bank with the intention of relinquishing all parental rights and responsibilities, and that paperwork would be used as evidence to show that donative intent. Because donative intent is what needs to be shown at the later stages of this. We were talking about the surrogacy agreement, but the next stage after the surrogacy agreement is really to file a parentage petition and to get that order of parentage. And as part of that, you want to show that there was donative intent by any of the donors, and you would attach those papers to show that.
So many steps to surrogacy.
Yeah.
Okay,
so
we've got the surrogate's pregnant. We're now in the second trimester.
Yes.
Now we have more legal things to do. We have to get a parentage petition. Why do we need to do that if we have a cis hetero couple that donated sperm and egg?
Because they are not considered the legal parents until there is a parentage order. So just to backtrack to my own situation, my husband and I were not the legal parents of my daughter when she was born in 2017. The birth certificate for my daughter listed my sister as her mom and listed no dad, because my sister was married at the time and is still married, and her choice was to put no one or put her husband. And I was 100% the biological donor of the egg, and my husband was 100% the donor of the sperm. It was 100% genetically our child, but we were not on the birth certificate. And so at that time, what we had to do, because this law wasn't in existence, is not only did we wait 9 months for her to be born, but after she was born, we then had to file a petition in court, wait another 9 months to get through the court system, and finally be declared her parents through a post-birth judgment of parentage, which we then had to send off, get a amended birth certificate, and now we're, of course, her parents on the birth certificate as well. But it's really that court order that was most important. During that time period, it was really, really difficult. I mean, emotionally, it was difficult in the hospital. because, hospital staff would congratulate my sister on her beautiful new baby and talk to her about her breastfeeding plans. And I'd say, oh, over here, I'm the mommy.
Mm,
We couldn't go and get a passport for her. We
right.
couldn't take her for, we did, but we really should not have been able to take her for medical appointments because we're not the parents. We're just, aunt and uncle, I suppose, taking her for her medical appointments. We couldn't take her on an airplane without getting a letter signed from my sister saying that, I am the mom and, Jennifer, the aunt, can take her on an airplane. So that was
Oh
really
my God.
moralizing. And that is one of the major reasons why I went into this area of law, because I want to be able to help people through that when they're going through it, because I can empathize with that situation and I want to prevent it when I can. And this law
Yeah,
has really changed things because now that's preventable.
thank God.
So now in the the second trimester, and we wait that until that time period because we know that a pregnancy has been achieved. We hope that it's going to continue. We have enough growth with the baby to know that we're looking pretty good. And we want to do it early enough that if a baby is born a little bit early, we have an order in place. So now we can get a pre-birth parentage order. And the pre-birth parentage order shall be granted, that law says, and that's very important here, shall be granted if these requirements are met. And so the requirements that I mentioned, and there's additional requirements in terms of the escrow agent. I didn't mention that before, but how are we going to pay her? That's also in the law. Putting it into an independent escrow agent, the timing of things, all of these things that I talked about, even the signing of the agreement, all needs to be done before medications start towards an embryo transfer. So we need to do these things very, very early. We need to do these in a very methodical way so that all of these requirements are met. And once we meet those requirements, we just show in that parentage petition that the requirements are met. Then we're going to have to attach, most likely, and I think the law specifically says to attach the surrogacy agreement. We're going to get certifications from the attorneys on both sides saying that they've reviewed the agreement and that in fact the requirements are met, and that because the requirements are met, we should be entitled to that pre-birth parentage order. And so that really is the goal, is to get parentage determined as quickly as possible.
So then when the child is born, the intended parents can go right on the birth certificate.
Exactly. So there'll be no amending. They will be on the birth certificate right from the beginning. The attorneys, once they get that order, would give a copy to the parties and make sure that the hospital is made aware of that order. And so that hospital should have them on the birth certificate right from the beginning.
Great.
And that hospital should regard them in all respects as the parent. If God forbid there's a situation where someone has to go into the NICU, who are they going to look for to make those decisions? And that's why it's so important to have that pre-birth order, because even if in your agreement you have, and you will have this, that once the baby is born, the baby is entirely the responsibility, good, bad, or indifferent, of the intended parents, and they are the ones to make the decisions, the hospital may not look to them without that order. So they may not abide by that agreement, because that agreement is only between the parties, not involving the hospital. So you want to get that pre-birth order to make sure that the hospital knows that you are the ones, as the intended parents, to make all those decisions.
And does that typically happen quickly? Because I know that you said that the last time it was like 9 months until you were declared the parents, and it's like, well, we don't really have that long until the baby's born. You know what I mean? Is that a quicker process, hopefully?
Hopefully. And that's all I can say is hopefully, because the
yet.
law has only been in place for 2-3 weeks now, not even a month yet. And so we don't know, because in order to qualify for these pre-birth orders, we need to be doing this under the CPSA and meet all those requirements. We could not meet all those requirements before the law came into place. So I can tell you in about 9 months from now, perhaps, or 12 months from now, but we just don't know. But yes, the goal is to do that. We have members of the art community, a lot of attorneys have been meeting with judges who are aware of this and trying to educate everyone on what is going on here. And everyone knows that there are specific time frames. And so that's why our expectation, and our very solid expectation, I would say, is that it's going to happen quickly.
Okay.
Like I said, it's only going to require, or should only require, one court appearance. I think that we're going to get to the point where it's going to require no court appearances, where just on the papers, if they're reviewed and if everyone has everything in order, it will be granted. And so if we can dispense with that court appearance, it'll obviously move things along a little quicker.
Yeah. Yeah. Wow. Okay. So lots of moving pieces when
Yeah,
you're going through surrogacy, but
yeah,
from what you're saying, I mean, it's just this new law just makes it so much easier and makes it so much better than when you went through it just a
yeah,
few years ago.
yeah.
And at least the intention of it is to to make things easier and smoother for all of that.
I
Is there
think
anything?
the end results will come about more easily. I think getting there, there's a lot of, I wouldn't say roadblocks, but a lot of requirements.
Right.
Insurance reviews that I haven't even touched on, to make sure that the insurance for the carrier, the surrogate, is in place, to make sure that she doesn't have exclusions, so we know who's going to carry, who's going to be responsible for all of the payments for the newborn, to be responsible for payments for the delivery. All of that has to be looked at in the very beginning. And the intended parent is going to be responsible for that.
Right. And the intended parents also pay, I'm assuming, for the surrogate's lawyer as well, right?
Yes, they do. Yeah. So they pay for pretty much. I think you should go into this assuming you're paying for everything if you're an intended parent.
Right.
It's not cheap, but in the end, what is the goal here? The goal is to make sure that you have a clear order of parentage. And
Yeah.
if you do this correctly, you should have that clear order of parentage. So it's going to be frustrating perhaps to get through all of those requirements, and it might be a little bit costly, but you're going to get that order. And that's really the most important thing. So
Awesome. That's great. No, I didn't know all of the pieces of the surrogacy part, but the pre-birth, that's amazing. That's
yeah.
because I was like thinking about like what, because there's like a lag when, like, what if something happened to the carrier in delivery? Like, who is
Yeah,
that child belong to?
right.
Like there's like there can be a gap of like what, like, and then what is the
And that's,
social worker going to have to come and so I think that this is great.
and even just to touch on that, there are additional requirements in this law that require that as part of this, and this is before the surrogacy agreement is signed. So this is all on the front end, that there needs to be, the intended parents are actually required by law to have a will and guardianship put into place before the transfer even happens, saying that if something was to happen to them, who's going to take over and be the guardian of that child? Who's going to
Mm,
take over the responsibilities under this agreement? They
mm,
need to name someone to stand in their shoes, essentially, to be the guardian of the child after they're born, and to stand in their shoes and to carry out their responsibilities to the surrogate during the pregnancy, should they pass. And on the
wow.
flip side, the surrogate, generally in these agreements, it's not required, but it's a very good practice to make sure that she has a healthcare proxy, someone that is going to um, stand in her shoes and make her decisions for her, and that there be a living will with advanced directives showing that if she should become incapacitated, let's say she's in a horrific accident, but the child's still viable. Well, what's going to happen at that stage? So that needs to be discussed beforehand as well. And that is usually put in as part of people's intentions in the surrogacy agreement. And if there's a
Jeez.
living will and a healthcare proxy, that would take care of that as well. So that's what I would recommend happen, even though that's not specifically required. It is ASRM best practices.
Yeah.
It is best practice for people going through this, to make sure that it's very clear that the surrogate would keep that baby alive for as long as possible, with certain requirements, and what those requirements are, and what her decisions are, because remember, it's her decision,
Right.
but that she's going to make that decision, and that's her intention. It's at least important to make sure that that's clear, so everyone's on the same page, and she has someone that's going to stand in her shoes to make those decisions for her.
Okay.
Yeah, there's a lot to it.
Lots of right, lots of things, and that's why it's so important to find an attorney who specializes in family formation and surrogacy, and that you each have an attorney, the surrogate and,
Yeah.
I mean, which is required, but the intended parents, to make sure that everyone's best interests are taken care of. Well, this was very meaty and very juicy. And thank you for sharing your story and your wisdom. And yeah, this is a lot. I didn't know
It's a lot.
anything about surrogacy or anything involved, but Jennifer's information is going to be in the information box below. Her information is on connectingrainbows.org if you want to find her. She does all types of family formation law in New York specifically, and is awesome, as you can tell. And so, yeah, thank you for sharing.
Thank you so much for having me. I appreciate it.
Of course.